Well, on the question of what is for cause, what the district court held was that it must relate solely to in-office conduct. And you defend that with one caveat that if the office holder is indicted while in office for pre-office conduct, then that might be cause for removal because a person under indictment wouldn't be able to devote full attention to the job. But other than that, you defend the district court's holding. Is that correct?
We do defend the district court's holding on that, and I would understand that is the rule for all the statutes that have INM.
There's nothing when under a for-cause removal standard, there is no pre-office conduct that could constitute cause.
That is my frontline response. I happen to have a backup argument, which is if you pick up the common law, then you would pick up
let's take your front line argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be for cause. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be INM. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had INM for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these hypos are going to eventually go, Your Honor.
But, because your position
I'm going to stick with my position. Of course I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat, and the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years
Mr. Clement, what's your backup argument?
My backup... My backup argument is the common law standard. Justice Sotomayor alluded to it, which would be that there's a removal basis for an infamous crime of the kind that is disabling for public office, and at common law it also required a conviction. So it's an exception. It helps me with a couple of these hypotheticals.
No, it doesn't
but it's
help
not going to help me with the Justice Alito.
It doesn't help
saying
you.
There's no conviction for the Hitler video.
You have a backup to the backup.
Impeachment. It's the ultimate backup here. This is not a situation where you're being asked, have to tie yourself to the
argued in the past that impeachment doesn't cover private conduct. You obviously disagree with that, then.
Well, I certainly see, but this actually kind of makes the point about judicial review, right? I mean,
I'm not saying I agree with that, by the way. It's just been argued.
Right, but what I absolutely agree with is the Walter Nixon case says that there's no judicial review of the impeachment determination in the end. Mm-hmm. So whatever the House and the Senate ultimately determine, I mean, they can make constitutional law too, and they can determine whether private conduct is or is not out. And if they say, and with these hypos, I mean, we can go down the road of the hypos and they'll get worse.
The backup, to use Justice Gorsuch's term, would be the infamous, but you don't need a conviction.
Right. No, absolutely. And of course,
that seems to answer a lot of the difficult hypos, correct?
Correct. But the reason I want to spend at least a moment answering some of the hard hypos is not because I'm a masochist. It's just because those are got to be the answers under INM.
Your answer is that those are funneled to the impeachment process. That's
right. And that's the way INM has worked for 150 years, and I think it would continue to work. It hasn't proven a problem in practice. But I'm not resisting very hard the backup to the backup on that because I don't think we're close. And, of course, look, all of these are hard questions, which is all of the reasons why it's kind of crazy to decide this on an emergency application.
Yes, well, there are a million hard questions in this case, and it is an emergency application, and very difficult questions, either no precedent or very conflicting or very uncertain body of precedent. But there are two things were decided by the lower courts. One, that what I just explored. The district court said it's got to be in-office conduct, nothing that happened before person took office counts. And then the D.C. Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the D.C. Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument. And I do want to talk about
why wouldn't that be a basis for sending it back to consider these arguments in the first instance? If you aren't prepared to defend the due process argument and perhaps your frontline argument on that things that happen before employment are categorically and always off the table. If those two decisions, which, to be fair, were, of course, issued under a time constraint, might have some flaws, why shouldn't it go back to reconsider it? You've advanced a lot of new arguments here. So have your friends on the other side.
So it should go back. It should just not go back with an emergency stay being granted, which is an extraordinary relief that depends on my friends on the other side showing an extraordinary burden of irreparable harm and showing that they have a likelihood of success on the merits. And I think likelihood of success on the merits in this context doesn't mean just a likelihood of showing that the two grounds that were seized on in the quick briefing below are wrong, but that they're actually right. And I think the briefing here has done two things. I think it showed that we're right. I'm not abandoning my frontline arguments, but I love my backup arguments. I think they are very strong. And I think it shows the sort of, the problems that happen when you try to decide some of the most important issues of constitutional law in this kind of rushed way.
Can I ask you about the mandamus question? Why isn't mandamus the appropriate avenue here?
It is an appropriate avenue at the end of the case. Even at the end of the case, though, I think, and this is consistent with what Professor Bray says in his article, even at the end of the case, I don't think you have to leap to mandamus. I think you can have a declaratory judgment
Well,
first.
Let's put the declaratory judgment issue aside because we can talk about mandamus for just a second. Assuming there is such thing as a preliminary injunctive relief for mandamus, which I'm going to ask you if that's a thing, first of all. And second, if it were, wouldn't the standard that you'd have to show likelihood of success be the likelihood of success under the mandamus standard?
So a couple of things. I mean, I don't like hearing preliminary mandamus any more than Judge Friendly did.
No.
I don't think it's the right way to think about it. I think it's preliminary relief to preserve the status quo, or if you want to be more specific, preliminary relief to preserve a de facto officer in their office while the case proceeds. And that is a relief.
Why isn't that preliminary injunction or mandamus? I know what those two buckets are. I'm not sure I'm familiar with the third one you're describing.
What I'm describing is a preliminary injunction. I'm just saying it's not a preliminary mandamus. It's
wouldn't it have to be, though, if your cause of action were mandamus, and let's just suppose that's what it is, it would be preliminary injunctive relief because you have likelihood of succeeding under the mandamus standard, I would have thought.
Well, perhaps. I mean, two things about that. One is, I'm not sure in this kind of mandamus posture, I don't think I agree with General Sauer that the standard is the standard you would have in like a Cheney situation. I do think this kind of original mandamus as the remedy in this particular situation, I would resist the idea that that's sort of the standard, more appellate mandamus standard. That's a debate, even with all the briefing we've had, we haven't had a good chance to really duke it out on that. But I would say that's part of the reason I resisted the idea that you have to go to mandamus, because I do think you would have declaratory judgment. I do think declaratory judgment.
I asked you to put that aside for the moment.
And I tried to, as long as I could.
All right.
But
then I give up. Okay.
Then to answer your question, I really had to get to declaratory judgment. I would like to say this is an issue the D.C. Circuit has thought a lot about. And there's a particular case worth reading, the Swan against Clinton case. And that's a case where they kind of wrestled with this question about would you have mandamus against the president at the end of the day? Can you direct the president? And there's a great concurring opinion by Judge Silberman where he basically says, look, the judiciary is creative and clever enough to figure out a way to fashion injunctive relief against the lower federal officials. And that solves the problem about having the relief run against the president. And the reason that the D.C. Circuit has wrestled with that in a couple of contexts, and I think the Chief Justice alluded to this, if they were really right about that, then you'd have to wrestle with this at the beginning of the case as to whether there's any redressability at the end of the case.
Justice Alito?
Do you think that we should decide this case on the factual ground that what is shown by the materials that are before us shows nothing more than gross negligence, which is insufficient? Should we make that factual finding in the first instance? I understood your answer to be you should do that if you're going to find in favor of me, but you shouldn't do it if you're going to find the other way.
I'll stand by that answer.
Really? That's your answer?
That's my answer. I think it would be a little irregular, but this whole case is irregular. And if that seems to be the path of least resistance to decide this case in a way that is going to essentially obviate the need for this court to decide it again in a couple of years, that seems like a perfectly reasonable way to decide the case.
Thank you.
Justice Kagan?
What do you understand the government to mean by gross negligence?
This? I don't really know. I don't think they've offered sort of a theory of gross negligence, and that's why I don't think
You think it's just a label that they've put on this particular set of facts?
Sure, and if heaven forfend we end up with a whole common law of Fed governor removal, then we might eventually be able to sort of piece it together. But it seems to me that, you could label an awful lot of things gross negligence, and that seems to be inconsistent with not just the for-cause provision, but the whole structure of the statute. And, Justice Kavanaugh alluded to the Morrison dissent and, Justice Scalia creating this beautiful picture of some independent counsel with nothing to do but to find a crime on somebody. But if all the independent counsel has to do is find gross negligence, then I don't think the independent counsel would need more than a couple of hours with most of us. That's such an elastic standard. And I just can't imagine that's consistent with all the trouble Congress went to make this unique entity insulated from kind of the political pressures of the day.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
A couple things. Just to talk again about the standard. Getting the definition of for cause right, which we may not have to do in this posture, so I take that, is critical, because on the one hand, you have the independence of the Federal Reserve, which we've talked about. The other hand, we have people have committed, again, not talking about the facts of this case, but serious ethical or other wrongdoing, digging in and remaining in office. And it seems like your two answers to that, when you said your frontline positions, I&M, were intervention/resignation. And I'm not sure that really works with some people who are going to just dig in. They're not going to leave. And then the other was impeachment, but of course, with the 2/3 requirement in the Senate and the time constraints of the House and Senate, I'm not sure that's available as often as you say. All of which is getting me to the point of, I don't see how the frontline position really can be the final position without kind of tilting the balance here too far the other direction from where the Solicitor General is. You just want to tackle that at all? You've covered it, but I want to get it out one more time so you can succinctly answer it.
Sure. I think the best thing that I haven't said already that I could add is I think in the unique context of this particular agency, you want to strike the balance more in favor of keeping an official who maybe in a perfect world would be removed, because, this is the opposite of the situation in essentially all of the other situations, with the possible exception of like the tax court and the court of claims and the court of military appeals. Here, I think, it's less important that the president have full faith in every single governor, and it's more important that the markets and the public have faith in the independence of the Fed from the president and from Congress.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Turning to the question of whether or not in-office or pre-office misconduct can constitute cause, I want to make a statutory point, which is that the I&M standard is, on its terms, limited to in-office misconduct, and Congress did not adopt that here. They adopted the more capacious standard, as this court recognized in Collins against Yellen. Cause gives the president more discretion, provides less protection to the officer than the I&M standard does. And even if we were in a situation where you're looking at the 19th century case law and so forth, they disregard a series of cases that hold that pre-office misconduct is sufficient cause. For example, in Ray Gooden, from New York in 1902, which involved an officer who engaged in a kind of shenanigan in order to get the office in the first place. There was a corrupt agreement to appoint somebody to a position if they supported that person politically. Iowa against Walsh, which was pre-office embezzlement. Gill against Watertown, a case they rely heavily on. It was said in dicta, at least, that gross frauds committed before office would constitute cause to remove. So there really isn't support anywhere for this notion that pre-office misconduct can't be considered when it comes to a cause standard. And related to that, I thought it was very telling that Mr. Clement was saying that if it does come to pre-office misconduct, impeachment would be the only remedy that would provide it, which, if taken to its full extent, would make governors of the Federal Reserve have the kind of tenure protections that the Constitution affords to Article III judges. That is not what this statute says. That is directly in the face of the statutory language, which says cause with no further restrictions. Clearly, Congress envisioned that they could be removed for a good enough reason. And on that point, I just want to emphasize there's this colloquy about whether it should be sent back or decided now in the merits. Whichever way the court comes out on that, the court should send it back with an emergency stay. And I want to emphasize two reasons there. This court, no court should hold that the misconduct that's alleged here, which is at least gross negligence, at least an inadvertent notation that is a grave misrepresentation on a mortgage document that's designed to determine the governor's interest rates, is not cause to remove a principal officer of the United States who sets interest rates for the entire country. So all the discussion of what are the outer bounds of cause, where is judicial review, on that fundamental court, neither this court nor any other court should look at this and say, this is likely not cause. That sends the wrong message to the markets. It sends the wrong message to the American people who have to make correct representations to their banks when they're getting their mortgage interest rates. And the second point I would make is the remedy granted here, a preliminary injunction that runs against the president, reinstating a principal officer of the United States, is something that has never been granted before 2025 in this court or in the nation's history. And in fact, contradicts a clear holding of this court in Sawyer that a preliminary injunction is not available in equity. Those two reasons alone clearly suffice to send it, if there is going to be a decision to send it back with the emergency stay that we've asked for. And then if the court decides to sort of send the case back to have many more of these issues that we've discussed today to be aired, we would urge the court, and I think Mr. Clement wouldn't disagree, to direct the lower courts to proceed very expeditiously. Here, we are in an emergency stay posture. The executive has been suffering irreparable harm since early September, and the sooner that these issues are resolved, the better. Thank you.
Thank you.